We'll continue. Delighted to have two old friends around the table, Jens and Meg, right on, mostly through your international criminal law activity, which is an interest we have in common, and I think connects in interesting ways to the Evans fiduciary theory. Both coming from the US, Meg at Temple and Jens at Cornell. We both have a Montreal connection of sorts. I mean, you actually grew up in Pointe-Claire, yes, you're part of the Montreal diaspora. And your supervisor will still shame us who can still consider a Montrealer at heart. So, Jens, do you want to start?
Yeah. Microphone here for maximum amplification. So first off, it's just it's a wonderful pleasure to be here, and it's a real treat because the book is just it's not just brilliant, but it's so stimulating for so many different areas and topics, many of which we've seen explored today, but many of which just can't be explored in such a short format. So I urge all of you who haven't read the book or haven't read all of the book to pick it up, because there's really something for everyone in its pages. So I want to talk a little bit about international law and jus cogens, and primarily about natural law and how that fits into the picture. And I hope at the end of the presentation, maybe we can get some clarity on where the fiduciary theory fits within those categories. So I'd like to start historically at the beginning of international law. International law was once an enterprise that was very much dominated by natural law. So if you go back and read the major treatises and also government statements about international law from the 1800s, the source of international law was inextricably linked with natural law. And so the major promulgators of legal norms were international lawyers who wrote these very lofty treatises, which read like part law, part philosophy mixed together. If the previous discussion of sort of Kant and rights and reason seemed obscure and philosophical, if you read those legal treatises from the 1800s, that's what you'll get. You'll see this kind of rich connection between the two, and it's because international lawyers believed that natural law was the foundation for all of law, not just international law, but domestic law as well. Well, this sort of view, which certainly lasted through till the 1800s, eventually came to an end when legal positivism took over and the natural law era came to its close. For me, of course, this is a gradual process. It didn't happen overnight, the sort of end of natural law. But I like to point to a particular case which I discuss in my paper, which I find very emblematic of the decline of natural law, and it's a U.S. Supreme Court case called the Antelope from the 1800s. And the Antelope was a slave ship which was approaching the United States sort of off the coast of Florida, which at the time was not part of the United States yet. And the slave ship was captured by privateers and then also brought to the United States. It was a little bit unclear where the slaves were destined to land. They were supposedly going to Cuba, but there was some suggestion in the case that perhaps this was a ruse and the slaves were actually being sold or brought to the southern United States to be brought into slavery. Anyway, the Antelope is captured as presumably as a prize under the rules for capture, and the Supreme Court of the United States has to adjudicate, well, what is the status of these slaves on the ship? And the answer for them depends a little bit on the answer to the question, is the slave trade illegal under international law? Is trading slaves a violation of some norm of international law? And the court is really in a dilemma here, because if they look to the positive law, if they look to treaties, if they look to custom, there's no rule of international law that says the slave trade is illegal. There's certainly no treaty that's universally binding on all states saying that trading in slaves is illegal. And they also look at custom and they say, well, some states have banned the slave trade. The United States had declared it illegal. The federal government had. And the UK certainly had, but plenty of other countries, imperial powers, were still engaging in the slave trade. So the Supreme Court says, how can this be a violation of customary international law when state practice is conflicted? Some states are supporting it and some are not. And then they say, well, under natural law, clearly slavery is illegal. Under natural law, slavery is abhorrent. It violates every principle of natural law we could think of, but natural law is not the source of international law. It's like them saying, we are lawyers here, we are not philosophers, we are lawyers, we look to positive sources of law, right? We're not some sort of court of rinky-dink philosophers, we are a court of lawyers, and we apply positive sources of law, and therefore the slave trade is not illegal under international law. And it has this, I mean, if you want sort of a compelling example of what's at stake here, all of the slaves on the ship then go into slavery, and they are not freed because of this dispute between whether or not international law is positive law or has a natural law basis. Okay, so we now live in this era of positive international law. We look to the positive sources, we look to treaties, we look to custom and other sources of international law. Well, the way I see it is that that result is very much intolerable for international law. This kind of there's no room for morality, and so natural law makes a kind of covert reintroduction, a kind of covert return into international law under the guise of jus cogens. What is jus cogens? Jus cogens is that part of international law which is mandatory, it's obligatory, it's non-derogable, meaning every country has to follow it regardless of what custom says and regardless of what treaties says. It's in a phrase that the Evans quote in the book, it's the ethical minimum of international law. The thing about jus cogens, which is kind of an indispensable category now for international lawyers to use in their arguments, it shows up with regard to slavery, with regard to genocide, with regard to torture, with regard to a lot of other prohibitions in international law, is that it doesn't fit very neatly within a classic theory of the positive sources of international law. It obviously can't be based on treaty law because the whole point of jus cogens is that it's not based on consent and it's hierarchically superior to treaties. A treaty norm will conflict with jus cogens, then the treaty is invalid. So obviously it doesn't come from treaty. It doesn't seem to come from custom as well because it's not based on consent, and even if there's a putative norm of custom, it would be that violated jus cogens, then it wouldn't, the custom wouldn't be valid. So it seems to have this kind of obscure position in the framework of international law. The thing is that contemporary international lawyers aren't inclined to think of it through the lens of natural law. They just call it international law, and then when you force them to explain how that fits in with a theory of the positive sources of international law, there's a kind of either hemming or hawing, or there's an incomplete answer, or there's a kind of refusal to engage with the question entirely. What I think about the sort of role here of natural law and jus cogens is that although the only sort of conceptually coherent way of thinking of jus cogens is to view it as natural law reincarnate. It's this kind of explicit incorporation of ethical or moral principles into international law that stands outside of the positive sources. Right? That's the only conceptually coherent way of thinking about it. International lawyers today don't think of it necessarily in those terms, and in a strange, ironic way, I think that's a good thing, and that's sort of the point of my paper. Why do I say that? Well, if jus cogens had been understood transparently as natural law reincarnate, that it never would have been as successful as it was, right? So the kind of heyday of jus cogens is that, I think of the kind of heyday of jus cogens and non-derogable norms as very much in that sort of post-World War II period when you get the human rights revolution, international lawyers and states start to talk about human rights norms. Of course, a lot of them do come from treaty law, but there's an understanding that some of them rise to the level of jus cogens. In that period, in the 40s and 50s and 60s, all the way up to today, if everyone had understood that what we were doing with jus cogens was bringing back natural law, qua natural law, international lawyers would have said, no, we're not interested in that, and they would have rejected the concept entirely. And I think that's how strong legal positivism's pull is, that we have this sense that law is different from morality, law is different from philosophy, it's based on these positive sources, where the law has this kind of autonomy, and if there had been this choice, right, do we either accept jus cogens as natural law, or do we reject it, the choice would have been to reject it and to maintain fidelity to legal positivism. So in a sense, it was a kind of stealth attack, right? Jus cogens came on board and brought back natural law, and it's a kind of good thing that there was all of this kind of subtlety, messiness, confusion around what it is. The lack of conceptual ground for jus cogens explains, I think, part of its great success over the last 60 years, and it had a big difference for international law. I don't think that the human rights revolution would have been possible. It certainly wouldn't have occurred the way it occurred if it hadn't been for jus cogens. So it's not just this little concept which we have natural law to thank for. It's the very kind of intense structure of the human rights revolution that we live in today. We owe to the incoherence of jus cogens. It's a little bit odd for me to say to make this argument, because I'm sort of trained before I was even a lawyer. I was trained as a philosopher and then went to law school, and so my sort of whole life was geared around the idea of making things conceptually clear and transparent. But here I'm arguing for the opposite, that obscurity was sometimes a good thing in terms of the practical result. Okay, how does all of this relate to the fiduciary theory? Well, I think that one thing that's great about the fiduciary theory is that it offers an explanation of jus cogens and why we can have jus cogens. And I think I share the fiduciary theory's answer here. I think it's got a very nice, clear explanation of what jus cogens is doing. To sort of put it down to just a couple of sentences, I think that the idea here would be that states have a joint fiduciary obligation both to their own people as well as to all of humanity and the other peoples that make up humanity, and particularly because of that joint fiduciary obligation, they have a non-derogable set of obligations that can't be contracted around through consent. So you have to treat your own citizens and you have to treat other citizens respectfully in accordance with that obligation. We could debate about, well, what's below that? Is it republicanism or Kantianism? That doesn't really matter for our purposes here. But the point is that relationship somehow explains why there is this non-derogable content to international law. And I think I share this view very much. So what I say here is mostly an intramural dispute with the fiduciary theory. Now, one thing that I find very interesting, and this is where I want to sort of end my comments, it's a little bit unclear to me the degree to which two Evans would accept my description of their fiduciary theory as a natural law theory. Particularly in the chapter on jus cogens, there's this, for me, very telling exercise where they go through and they talk about the previous attempts to explain jus cogens, and they go through the various theories, and they show how each one is in some way discredited or implausible or was rejected, and then they posit the fiduciary theory as a more plausible alternative to explain jus cogens, and it's the sort of unpacking what I said before about that dual fiduciary obligation to those two communities. Natural law is included in the list of one of those theories that was rejected as a ground for jus cogens. It seems to imply or suggest by implication that what they're doing is not natural law, or they wouldn't use those terms to describe it. But I certainly would describe their theory as a natural law theory. Why would I describe it as a natural law theory? Well, part of this depends on how one uses the term natural law, and maybe this is a semantic dispute, I don't know, but when I think of natural law, I think of that area of the law after the positive law runs out. Something that's flowing from some source that is not the positive law, not treaties, not custom, not subsidiary sources of law. I call that sort of dark hole from which norms emerge with a gravitational pull. I think of that as natural law. Maybe that dates me somewhat, but I think once you're in that dark hole, you can call it whatever you want. It's really some extra positive norm, and that's natural law. Now, one way of getting around calling it natural law, not calling it natural law, is to say, well, that black hole is just ethical or moral, right? It's normative, but it's not law, right? It's just pure morality. And we do that. Sometimes people construct these theories, and they're clear that what they're doing is engaging in a theory which is a moral theory, and they're suggesting a way in which the law could develop. Basically, lex ferenda. This is the way the law should move in order to become more moral. The way I read the fiduciary theory, and in particular the way I read the book, is that it's claiming to be more than just a moral theory. There's a particular few lines in the chapter on jus cogens where they say, no, this is actually a legal principle as well. We're saying that this theory of jus cogens is part of the law. It stems from the principle of legality. It's law-like, so it's not just a moral principle. I think once you've done that, you've committed yourself to saying that what we're doing here is presenting a kind of natural law. Maybe to distinguish it from the historical natural law, we can give it another name. I'm sort of coming around to the idea that we could describe it as neo-natural law or something like that. It's today's natural law. But of course, as I've said before, maybe it's a good thing they're not calling it natural law, because people are so allergic to the notion of natural law that the success of these things is hampered once you call it natural law. And in fact, maybe I shouldn't have even given this presentation because the whole enterprise will collapse. So just forget everything I said. It's never happened. But really, I think there's an interesting sense here to think about what exactly is the nature of this enterprise, and do we think of it as being natural law, and do we think of it as being law-like, and what is its sort of structure? You know, at the end of the day, there's in the book there's this sense in which they're bouncing back and forth between the structure of they're finding these principles in the structure of the law as it is, but then they're couching it in terms of a principle. That's fine, but once you say that it's actually part of the law as is, then I think you're committed to this kind of view that it's neo-natural law. And as someone myself who sort of appreciates and has written about natural law, that's what I think is sort of the most exciting part of the fiduciary theory, that it's kind of natural law for a new generation, natural law for the 21st century. And for that reason, I think it's very exciting. Thank you.
Thanks. So the evidence has been unmasked as crypto-naturalists. Well, we suspected all along. Meg, your concerns and paper have a lot in common, I think, with Jens and with sort of an endless quest for what makes the gravest international crimes, and whether we can do this without resorting maybe to mystical thinking.
Right, right. Well, I'm not sure that I'm going to be able to do it without resorting to mystical thinking, but j'aimerais commencer en français parce que j'aime beaucoup comme on utilise le français et l'anglais ici. Remercions aux étudiants et à Avenel de m'avoir invité à participer à cette conversation très intéressante, malgré que je n'ai pas pu écrire quelque chose pour votre volume, que je regrette. Mais that's in part because I have this book that has been hanging over my head for a very long time, and on this question of the gravity concept and the work that it does in legitimizing international criminal law. And I'm going to, since many of my friends in the room have sort of heard about this ad nauseum, I'm not going to talk about gravity today. But what I do want to talk about, and the reason that I wanted to participate in the conversation, despite not being able to write specifically on the book, is that I think the way that I am thinking about legitimacy, and particularly in the context of international criminal law, has interesting overlaps with and maybe points to maybe limitations of the fiduciary theory. At least I want to sort of suggest that and see what your pushback is, because it will also then help me sort of push forward my own thinking about legitimacy in this area. And I want to start by saying that, the book doesn't actually address international criminal law really much at all. So this is in some sense unfair. But I hope that it can sort of contribute to furthering your thinking, and you've said that you're starting to tackle questions about sort of conflict and tension that I think arise in this context, and this may relate somewhat to that future project as well. So the question that I'm thinking about is basically, to what extent can fiduciary theory help to explain the legitimacy of international criminal law? And even though you don't tackle it directly, the book does set forth fiduciary theory, as I read it, as a theory that can explain most things in international law, and so, why not, right, international criminal law? And the particular aspect of the book that I thought related most directly was the discussion of international institutions and the way that they, that their actions are legitimate to the extent that they abide by this fiduciary obligation. And so that could apply to international criminal laws institutions as well. So I'm focusing on legitimacy. You talk a little bit about it, but you don't, it's not sort of the central organizing principle of the book. So I want to be clear about what I mean when I'm talking about it and how I read you to be talking about it, and make sure that we're sort of on the same page, and I trust you'll correct me if I'm off base. So I think about legitimacy as importantly divided into normative and sociological, and I don't really, sociological being sort of perceptions of legitimacy. And I don't focus much on that, and I didn't read you to be either. You're really talking about normative legitimacy. And you, I think, and this gets to what Jens was saying, I think you don't distinguish between moral and legal sources of legitimacy sometimes, that you sort of conflate the two, as I do as well. And I do it maybe a bit more consciously and explicitly, because I want to avoid this question that Jens is bringing up of when are we in the law box and when are we in the dark hole box, that I think isn't always fruitful. I mean, I guess I want to accept that law and morality are intertwined and not sort of get into that philosophical debate too much in the analysis. Okay, then the next thing that I do is I think about what's the framework in which we're thinking about the legitimacy of law and legal institutions, and I break it down in terms of the objects, subjects, and bases for legitimacy. And I think about the object that I'm analyzing as a regime, right, comprised of norms, decisions, actors, systems, And in this sense, I think you are doing the same thing broadly with regard to the international law regime. I'm doing it in a more limited frame of international criminal law regime, but we're talking about, I think, the same objects of legitimacy. With regard to the subjects, though, I think you focus exclusively on states and state-like organizations and actors, whereas I would put the focus in terms of subjects on communities. Now, I'll get to that difference in a minute. Arguing that law and legal institutions are legitimate when and to the extent that they advance the values of relevant communities. And then part of the question is figuring out what are those values, which can get us into the black hole, where do we get those values? And also, what are the relevant communities? So figuring that out. And then lastly, with regard to the bases of legitimacy, it seems to me that you focus, and the fiduciary theory focuses on the obligations of non-instrumentalization and non-domination, and they do a lot of work, whereas I would bring into play a sort of more diverse set of values than that. So I would include those, and I think they're very helpful and useful to thinking about legitimacy, but I also, depending on the context, and I sort of would figure out the legitimacy criteria depending on the object of analysis, but I would bring in concepts of consent, fairness, transparency, sort of a whole range of values into the analysis. Okay, so to be a little bit more specific about it, what are some of the things that the fiduciary theory leads to? What are some of the conclusions it leads to that the community values theory might not quite agree with? So again, you don't talk a lot about international crimes in the book, but you do say that basically, and this is sort of one or two sentences, so forgive the spotlight I'm putting on them for now, that genocide, crimes against humanity, war crimes are illegal because they represent the state instrumentalizing subjects for their own public policy objectives. Okay, so yes, I think that's at least part of the explanation, but I wouldn't say it's the whole explanation for what constitutes the parameters of these international crimes. Okay? So then in particular, you focus on torture and say that, that torture is limited to pain and suffering inflicted by state agents for state purposes, right, such as obtaining information and so on. And I guess what I want to say, I think that the theory does in fact describe the law in this area, at least the human rights derived law in this area, but interestingly not the international criminal law in this area. And so this leads me to wonder sort of to what extent is international law different, and how does that then dictate the legitimacy frames being different? In particular, the way that international criminal law centers individuals, and most of international law centers the state, right? With regard to piracy, you say, it's not really an international crime because there's not really a nexus to the state-subject fiduciary relationship. And that doesn't track standard, and as you acknowledge, doesn't sort of track or describe the state of the law in this, except that I think it kind of does, because most of international criminal law talks about the core crimes as being the real subjects of interest, and piracy isn't really part of that. And so I actually think that your view of piracy isn't incompatible with the dominant approach in that way. And then I think the view also tracks the dominant, or at least one theory of international crimes more broadly, as all requiring state action. So Basuni and Chavis and others who write a lot about these issues really want to limit all international core crimes to crimes involving state action, state policy, and then the fiduciary theory does a lovely job of explaining, their parameters and why they're illegal. I also think it helps to explain the current state of institutional decision-making on when it's appropriate to exercise jurisdiction over international crimes. In particular, the International Criminal Court's complementarity requirement. So this is the idea, for those of you not too familiar with the International Criminal Court, that that institution should only, and under statute can only exercise its jurisdiction when states are not doing it appropriately, basically, right? So viewing the International Criminal Court's jurisdiction as essentially subsidiary to state jurisdiction. So how does the global community values theory through the lens through which I look at this differ? First of all, it decenters the state. And so I'm nervous about centering the state, as I was telling Evan to the right of me that earlier, that it decenters the state, and I'm worried about centering the state in any of this, because I think that increasingly the state is losing power relative to other actors in the system, and that even if you are right now to be the way that you're describing the importance of the state, you won't be in the long term, as corporations gain power relative to states, as other non-state actors gain power, as the internet gains its own power over all of our lives. So I think that I'm hesitant, I'm nervous about that idea of the state as the locus of legitimate power for a number of different reasons. And so in these concrete cases, how does centering community and community values change the conclusions about legitimacy? I disagree basically with the conventional definitions of core crimes. So I don't think that they have to be limited to crimes involving state action, that torture has to be limited to severe pain inflicted by state actors for state policy reasons, but rather that that those crimes are defined in terms of the values of a global community, and I won't get too much into that because I think I'm probably up against my time now, but that we have to think about what does it mean that really the whole enterprise, the whole regime of international criminal law is about identifying, implementing, enforcing global community values that go beyond the state, that incorporate the idea of states as fiduciaries, but that doesn't provide the outer limits. So that the definitions of international crimes, and this picks up a little bit on Jens's, like, let's keep this a bit ambiguous so that we don't constrain it too much. I kind of like that, because I think that as the loci of power change, and as the values of the global community change, and as the discursive process that co-constitutes the community and the values evolves, limiting the discussion to issues of state and sort of centering the state could potentially curtail the project in ways that would be normally undesirable in the long term, right? So similarly with this idea of complementarity and the idea that the states are in a better position to exercise jurisdiction over international crimes, yeah, maybe right now, and maybe that describes some aspects of the way that the regime is set up right now, but actually, if you look at the way that the courts, ICC is interpreting this principle, it's not interpreting it in this hierarchical way that most commentators espouse, right? It's actually interpreting it in more, I argue, sort of the global community values way that I espouse, and saying, there is a separate global community that has to have a voice, and we are charged with being that voice, not just with being a backstop for unavailable national jurisdiction. And so in that way, I think that global community values better captures at least some aspects of current doctrine, but more importantly, looking to the future, I sort of want to echo Jens and say, I think that there are some ways in which we want to be careful about limiting the possible expansion based on concepts like fiduciary. So I'll end there and look forward to your comments.
Thank you. So maybe you've now been unmasked as crypto-naturalist statists. Full argument for kind of benevolent fiduciary dictatorship. Patrick, you were the first to raise your hand.
Thank you. This is a small, 2 points, a small point and a slightly bigger point, and go to Jens's remarks, which I found really, really interesting. It's a rare sighting indeed to find a natural law scholar who admits he's a natural law scholar. Thank you. The small point is, and I think you would agree with this, it's just in the interest of clarity that you spoke about earlier, is that use cogents came wrapped in custom, right? It comes wrapped in custom. So
Super custom.
super custom. But most of the prohibitions actually really fit the tests, right? So, you know, torture and slavery, state practice, and yours is all, all the way down, right? What it doesn't explain is its permanence, right? So that's a very small point.
Yeah.
And the larger point is, I'm not sure the dark hole is that dark. And it struck me that you just said natural law is what comes in when positive law runs out. And that made me think, well, yeah, but only if you overlook the fact that it's underneath positive law. So positive law, when it's right, it should be a reflection of natural law. So natural law is there, but you don't need to resort to it. Right? Whereas if you think of it coming in when it runs out, it's not anterior, it's not ex post, it's not ex ante, it's ex post, right? And so maybe the better term is, I was first thinking, maybe the better term is post-positivism, right? Because you're not rejecting positivism. Positivism just answer the question. And part of the answer has a lot of positive law in it. And it's interpretation, but that doesn't really capture it as much as it's post-positivism. And I think you might want to hide behind that later.
Want to respond to that, or just take it?
It's very good. Thank you for that.
I also wanted to ask about this question of entrenchment and what accounts for it and the structure of the argument. So as I understand it, the praise of conceptual incoherence here turns in no small part on a socio-legal claim that's supported by the counterfactual. Right? So if Fiduciaries of Humanity had been published 70 years ago, use cogents would not have become entrenched in the way it did.
Yeah.
But your concern, of course, is forward-looking rather than backward-looking, as I understand it. The concern that the idea that we should maintain conceptual incoherence is forward-looking. It is. There are moments in the paper where it seems like it's forward-looking. So if it's not at all, then I could just clarify that. To the extent it is forward-looking, I guess I want to ask. Is the unmasking really a problem today, or are there various socio-legal forces that would keep the substance of these norms entrenched, regardless of the fact that you're going to be on YouTube saying, I have unmasked this, right? So to the extent your concern is forward-looking, I think there needs to be more in the paper to substantiate a claim that the publication of Fiduciaries for Humanity today poses a risk to the degree of entrenchment of the norms.
Yeah, so I'm a little bit, my presentation of that point in my paper, my draft paper was certainly ambiguous, but I think it's definitely a backward-looking argument, and I'm not seriously suggesting that if people read the book, then all of a sudden use cogents will collapse. It has to do with the way categories, the way categories are constructed and the way they are adopted, people are very sort of concerned about some points when they're first. The greatest moment of skepticism for a concept is when it first emerges, and then once it becomes entrenched, people stop asking so many questions about it because it's what we learned and it was there yesterday, and so the sort of moment of its greatest vulnerability is its first emergence on the scene. And so in that sense, right, I think my claim here is mostly a historical point, and it's mostly academic. I think I'm asking some sort of deep, sort of philosophical questions about what exactly is international law in the past and what is it today and the future. But I'm not seriously suggesting that the incoherence, or I'm not seriously suggesting that coherence is going to doom use Kogan's and human rights law going forward. I mean, that would be a silly claim. I'm not making that.
Can I just add something to that?
Thank you
I also think, Jens, you have to be careful about the extent to which you emphasize the naming by academics of things as being, I think use Kogan's emerged at a time when there was a real strong urge for the evolution of moral norms of human rights and so on. And so that was the more powerful force, and whether somebody called it natural law or not, I'm not sure would have made such a big difference, given the cultural, political force behind the emergence of the norms.
Yeah, I mean, I want to respond to that. For some people, I think it would have made a difference, right? So, I think if you think of like particular lawyers, some people were more significant than others, but if you think, for example, one of the things I talk about in the paper is the specific discussion of use Kogan's and the list of which norms are use Kogan's in the restatement of the law, third, written primarily by Lou Henkin. A lot has been written about how that was just like stuff he made up and put in the restatement, and a lot of that stuff became very influential. It had this, more so than other restatements, it had this generative aspect. It wasn't simply reflecting what was already there. I think to someone like Lou Henkin, if he thought that this was not law, if it was just morality, he wouldn't have been willing to put that, right? He thought of himself as a lawyer and had very much of a separation between law and morality. So much so that, like, for example, the humanitarian crisis, the Kosovo thing, when Lou Henkin was still very much alive, and he wasn't willing to accept humanitarian intervention as legal, even though it was moral, because he thought of a separation between law and morality. So I think for some people, it would have made a difference. But I take your point. For some activists on the ground, maybe they wouldn't have cared so much, and they were much more willing to accept a kind of moral view of the law.
It's good. Richard.
Thank you. I have kind of a hope-growing realization about the shape-shifting character of the fiduciary theory that I wanted to share with you. I've been struck at how people find a kind of affinity to it, and can call it all kinds of different things.
Yeah.
So we can call it a natural law theory, or we can call it republicanism, or we can call it post-positivism, or we can call it some version of community values. And on one hand, that might suggest that it is a kind of black hole in itself that is attracting all sorts of theoretical construction to it. Or it might mean, which happens to be what I believe, that it is actually a kind of meta-theoretical construction, by which I mean that its effort is really to map different sorts of claims and the bases that they can have. And if I could put it this way, even as we are fiduciaries to ideas, that is to say that we always have to have some relationship to what is inadequate in our own thought in order to be able to put forward, where is the limit of my conception? That's already a fiduciary notion in thinking. And now if we place that back within the conception of law itself, we have to say, well, what would it mean not to have a theory of law once and for all, where we have to vote, are we for community values, are we for this, are we for that? But we actually have to place ourselves in some relationship to the inadequacy of any theory. Then you get onto this template of fiduciary thought. I think that's something that should be grappled with a little bit more.
Do you want to answer the question?
No.
Sure,
a couple
just,
of
yeah,
sessions. We're discussing them.
yeah.
Okay, I have a question for Margaret, which was that you make your paper in distinction between international criminal law and human rights law. And I just wonder, actually, if the argument that you made applies to human rights law just as much. And I was thinking about points on complementarity, specifically with the question of, say, the Convention on Elimination of Discrimination Against Women. The moment that there was this, in the original text of the convention, there's nothing about private actors and violence against women. And it was after the Beijing movement that actually this was read into the convention. So it really is about this global community transforming what is the actual meaning of the convention to non-state actors, but violence against women generally as private actors, and then seeing it in terms of the state's obligation to protect women against violence, right, against this act. And under the individual complaints mechanisms, you have the exact same thing. You have the requirement to exhaust legal remedies, or you can bring, that's the case up to the CEDAW committee. So I just wonder, actually, if the critique is larger, your critique is larger than what you've projected in terms of saying that criminal law is really different from human rights, but in fact, they have the same problem with human rights law that they would with international criminal law.
Yeah, I think you're right. I guess what I was saying is that it makes, maybe it makes more sense to center the state in the context of human rights law, since the basic organizing principle is limiting state power there, as opposed to international criminal law, where I don't think that's the organizing principle. But I absolutely agree with you that human rights law also has a relationship to, and its development, happens through the evolution of community values. So I was just sort of making that more discrete point about maybe there's a difference in the sort of centering the state aspect. Thank you.
Okay, we have about 10 minutes left. I'm going to Ivor V. Evans.
Yeah, I'd be glad. So, Megan, yes, thank you so much for these wonderful contributions and comments. So I'd like to start with Megan, then move to Jens, and possibly continue with Jens a bit of the conversation we started with Patrick a little earlier. But Meg, first one with respect to legitimacy. So I think this is a huge, just so important, and it's so great that someone's working on it. So one suggestion I was going to say that in terms of a place that you might want to look, if you have it already, that a philosopher I find particularly clear about legitimacy and what it means in this sort of the context we're talking about, where it's not sociological. It's a guy by the name of Simmons. And what he distinguishes between, or says that there is a distinction between, is on the one hand, the sort of justifications policies might have, that they promote certain values, or they're good for certain people, they have certain virtues. That's sort of the justification of a policy on the one hand, but the legitimacy he thinks is something else. Legitimacy goes to the right to rule of a particular entity over particular people. So I know for some folks in political theory, it would be helpful if you were to say that by legitimacy you sort of mean both of those, or just the latter of those. Now in our work, Evans and mine are in the book, what we try to identify is what we refer to as a criterion of legitimacy, and it tracks just that, it tries to track that narrower conception, which isn't to say that there's not a lot there. So the criterion of legitimacy that we suggest is simply, you can tell whether or not a state policy or the policy of a public authority is legitimate by whether or not the effects of that policy or the exercise of a power can intelligibly be said to be made in the name of or on behalf of the people who are subject to it. So it's a kind of representational criteria, right? And we don't specify precisely, what does it mean to represent? So in some cases it might be consent. We do provide some pointers when it comes to human rights and use Kogan's. We start with, as Patrick pointed out, that everyone has an innate right to equal freedom with everybody else. The state has an obligation to provide a regime of secure and equal freedom. What does that mean? Well, then we have the intermediate principles that Evan was referring to of non-domination, which governs the terms on which power is held, and non-instrumentalization, which governs the terms of its exercise. That's all still pretty vague. So what else could it mean? More or less international human rights law, right? As humanity's first cut of what it means to provide a blueprint to all of us as individuals within particular states or collectivities to know how we're entitled to interact with one another and to those over who claim to have authority over us. Now, with respect to centering the state, we certainly, of course, we focus on the state, but we do, toward the end of the book, try to talk a little bit about global administrative law. We're entirely on side with you that the state, the influence and the salience of the state is surely diminishing, but still, states still are the central actors. They're the actors to whom external sovereignty is allocated, as Patrick rightly points out, and it doesn't look like there's going to be anything different on the horizon, at least from the standpoint of external sovereignty for a while. Doesn't mean there's not lots of other things going on, but I guess our sense would be that we could still use the fiduciary model wherever we find transnational communities or authorities purporting to act on behalf of others. They're in that sort of a circumstance, they're acting in a certain sort of stewardship role, and so there may be insights from some sort of fiduciary perspective. With respect to Jens, the question, is this a natural law theory? Well, it's a theory that traces, I would say it's best characterized as an interpersonal legal theory. So with that, it shares the kind of structure that we find in private law, and we're attracted to it being interpersonal because that puts sort of natural limits on the extent of obligations that may be owed in a theory that's otherwise quite expansive. But just as we can make sense of tort and contract without positive law, so too I think we can make sense of fiduciary relations, and we offer the Kantian model as a possibility of that. But again, importantly, we offer that model not to say, okay, from this we can sort of generate out all the the rights and duties that you see in positive law nationally and domestically, but rather take those rights and duties as given, or the core of them, and say, what's a theoretical framework that can help to explain them? And that's where we think the fiduciary model's helpful. Is it a natural? Is it strictly speaking natural law? I think you could make an argument that an inclusive positivist could adopt this theory, except they would simply say that what we're talking about is the difference between legitimate law and illegitimate law, whereas a natural lawyer would say what we're talking about is whether there's law there or not, right? So.
Yeah, just a couple thoughts on Jens' paper and then on Meg's, both which were terrific papers and really generated a lot of thoughts. So with respect to Jens' paper, one of the reasons why I think people are anxious about using the term natural law is that, well, perhaps at the time of the Antelope, everyone could agree that slavery was inconsistent with natural law. You go back a couple of centuries earlier and you find Aquinas and Grotius justifying slavery on the basis of natural law in a post-fall world. And so there's a sense that natural law is that it sort of kind of springs fully formed from the mind of a particular jurist. So I think the one reason not to use the term natural law is to kind of avoid that concern, and I think a proper humility in employing what we might otherwise call natural law reasoning is to subject it to the reflective equilibrium and see does practice sort of bear out what we would consider to be our or what sort of norms, anti-positive norms, are consistent with practice as sort of worked out through a deliberative process. And so I think that's one of the reasons why, at least I think that the methodology that we use in the book is, while you might characterize as natural law, is kind of informed by kind of a little bit of a different mindset about how we go about identifying norms. I do think one thing that I kept thinking about Cass Sunstein's article on incompletely theorized agreements when I was reading your paper, because Hankins' list of norms in the third restatement, several of those examples appear in that article. So racial discrimination, for example, Sunstein says we should pitch our legal rules at the lowest possible level of generality on which there could be broad agreement, recognizing that that's not going to answer all questions, but it's useful for providing stability and flexibility and so forth to the legal system. Racial discrimination being the classic example, so we might all agree that racial discrimination is is awful, but what does that mean for affirmative action, or what does it mean for other kinds of public policy programs? We have a harder time agreeing on that. And so the incompletely theorized agreement sort of helps us to mediate that in a way. But I think one of the stories we tell about our book is we're hoping that we've gotten to the level where we can kind of move one step down in our level of theorizing where the level of agreement is. We can move from that restatement of racial discrimination, move a level down, and actually use the fiduciary theory to tell us what is impermissible racial discrimination, what's torture, what would be violations of these other norms that we might all agree are worthy of censure, but this can help us to make a little bit progress in defining what those actually are in international law today. And going to Meg, I totally get your concern about the idea that our theory looks very state-centric. One way of thinking about this as applied to international criminal law is that today it remains the case that states have a monopoly on the right to prosecute and to use coercive force to incarcerate and so forth. And the fiduciary theory, one way of thinking about international criminal law is recognizing that monopoly on prosecution. We recognize that raises the problem with impunity, right? And impunity is, we've described elsewhere in our writings, institutionalization of domination. And so there's a role for the international community to involved, obviously, when there is impunity that imperils global norms. Norms that are of fundamental importance to the international community. So I think there's a way of thinking about this. In that sense, it's state-centric, but what those norms are and whether they apply to state actors, non-state actors, I actually think the fiduciary theory is open to the idea that international criminal law could target all kinds of offenses by non-state actors without necessarily even a state link, to the extent that the state is allowing there to be impunity in a way that undermines the essential values of the international system. So it's just something for you to think about.
Can I just respond briefly to that? I mean, more to the first Evan's discussion, because well, thank you for both bringing up all these issues. I was particularly interested in your invocation of inclusive legal positivism, because that's something I wanted to talk about in the draft, but ran out of time to talk about it. And I think that's very much one way you could go to sort of solve this problem is to
If it's a problem.
Well, if it's a problem, is to describe it as inclusive legal, to be an inclusive legal positivism, and if you're an inclusive legal positivist, you have room for positive, I mean, not for moral thinking with your legal arguments, and your positivism is consistent with that. It's a kind of watered down form of positivism, and if I was a positivist, that's the kind of positivist I would be, an inclusive legal positivist. I'm not sure how consistent that approach would be with some of the things that you say in the book, in particular in the chapter Use COVID. So I'm curious if you guys would view your approach as inclusive legal positivist. Because if you're an inclusive legal positivist, what you're doing is saying, we're legal positivists and we have law, but we're willing to mix it in with some sort of moral. There's room for an explicit consideration of a moral norm to help understand the law. If you do that, it seems like you're saying we've got the positive law here, and then the fiduciary theory is providing a kind of moral theory, but we think it's appropriate to use morality to help understand the positive sources of the law. It didn't sound to me like that's what was going on in the Use Kogan's chapter. It sounded to me like the fiduciary theory was being described as law. And if you're going to use inclusive legal positivism, I think you have to concede actually no, it's a moral theory, it's morality. We just think it's appropriate to mix moral theory with the law. So I'm kind of curious about that.
Sure.
Just say a quick response to Criddle. I don't actually agree that states anymore. I mean, I think the revolutionary nature of ICF of international criminal law is that states lost the monopoly over prosecution, and now international courts do it. And so that's what, and I guess I also don't quite agree that impunity is an institutionalization of domination necessarily. because there can be lots of different reasons why a community chooses not to prosecute. And then the question becomes, does the international community have a separate and independent interest based on this now, new ability to prosecute that international courts give voice to, as opposed to just being part of that? I mean, I guess that's our point of maybe disagreement.
All right, great. So I've actually been asked to conclude. I promise not to take too much of your time. Le français en moi est sensible au fait qu'il y a du vin qui nous attend. Il ne faut jamais faire attendre le vin trop longtemps. Thanks a lot to the organizers, to the McGill Law Revue first, and to our authors, to Evan and Evan, for providing us with so much food for thought. The book had the effect on me that this tune that you hear in, annoying pop tune that you hear in the morning and then can't get out of your head all day does. So I've been seeing fiduciary relationships everywhere. I dream about fiduciary relationships. I see my kids in a new light. I had all these obligations towards you. It's all very Kantian. So thanks for that. So what can we expect from a day like this, right? I think is maybe a good question to get us started. And I have to say, Evan and Evan, you're sort of usually ahead of us. Big head start. You've been thinking about this for a hell of a long time. I've witnessed your evolution and participated in some of the events you organized along the way. And so I think we're all sort of still digesting this and reacting, and it's a complex argument. I think as we write our contributions, we have to be very careful that, maybe you have actually made that argument at page 364 in a footnote, and we want to make sure that we don't misinterpret you. And then there's also a thing that this is really a kind of theory of everything, right? I can't understress how ambitious it is in a sense, but you cover a huge amount of ground. It's a theory of international law, human rights, and law, and the nature of authority, and so it is very broad and ambitious. And it's also, I think, it's intriguing. It's not just ambitious, but it's intriguing because you're actually proposing to revisit all of that through a fairly narrow private law institutions, right? Which isn't even part of the ordinary vocabulary of most international lawyers, right? It would be kind of news to them, but in a sense, welcome news that fiduciary theories can help them think through some of the dilemmas of the discipline. So I want to point some of the ways in which this is highly needed, and I really mean that. At the same time, some of the ways in which I think it's vulnerable, although that's also what makes it charm. First, I really believe that international law is too important, especially in this day and age, to be left to international lawyers. So thank you for, we need all the energies and all the potential for reinvention that we can get from other areas of the law and this kind of the sort of cross-fertilization that you're proposing. This is a tired discipline in some ways that has had a tendency to go in circles, and so we need to try to break out of that. At the same time, I think the bar is quite high. So we use the image of a spectrum and various international laws on it, so that there are those on the center right, as it were, who will be mildly skeptical of whether the theory describes anything that actually exists in the real world, leaving you vulnerable to the critique that you are merely utopian. There's a few things, the idea that states' authority to rule is determined or conditioned by their ability to discharge their fiduciary duties might appear somewhat true in certain European capitals, but I don't really think necessarily sums up the spirit of the times in diplomatic quarters, etc. I've just lost my screen. And then there will be those also on the left who will be wary that the theory describes the real world's implicit normative code only too well, and in ways that we don't need to further encourage, right? So maybe the argument is actually, yes, this is the way of the world, that everyone tends to think that they have fiduciary duties, and that's used in all kinds of nefarious ways. So I think there's a few meta challenges I think they kept recurring in our conversations today. The first is really, this is just a classic question, but the book sort of addresses it, but at the same time is always raising it anew. Is this a normative or descriptive theory, right? And can you kind of have it both ways? Do you end up sacrificing one to pursue the other? And I think, it's in a genre, and that I think is it's a niche, but it's also a very interesting genre of kind of non-ideal theory that tries to err fairly close to reality, but not to the point of being absorbed by its gravity pull, as it were. And so it has all the problems of non-ideal theory, that you'll either be accused of getting reality slightly wrong, or accused of being an apologist for it, right? And probably both. I think what's interesting to me is, and what commends the theory a priori, is that it has a certain plausibility to it, right? This is not something that international lawyers can dismiss out of hand. It comes from within a community of arguments. It has a kind of air of reality, as we would say in Canadian criminal law. And so there's different things. I mean, one is international law and private law were once not thought as that separate. I mean, grocers didn't really even think of themselves as international lawyers, a natural/private/ theologian, international lawyer. And then these debates, these kind of chicken and egg debates on whether sovereignty comes first and then the duties that come with sovereignty, or whether sovereignty is conditioned in the first place by international law that kind of vests authority in it. These are debates that are really as old as the discipline, and that any international lawyer will recognize as quite familiar. Now there's also some aspects, and I think this may have been hinted at during the panel that I couldn't attend, of a theory that are plausible and familiar, but maybe in slightly more awkward ways. And I've mentioned this to you already in a previous workshop. The fiduciary duty does sound like what every international colonial lawyer was looking for years, right? So I think you'd have been a hit in Berlin circa 1884, right? There it is. But fiduciary duty has that air of reality, is also reminiscent of that burden of civilization as a structuring idea in international law that has never gone away, and that, to quote Monty Koskiniemi, has moved away from the vocabulary of international law to its grammar, right? So that even if you don't use the language at all, and it certainly comes back to haunt international law, and therefore a lot of the conversations that we have about it. But I think the familiarity could also be, and the plausibility could also be that I think the fiduciary theory points to something that international law has always senses there, that there's a kind of parallel international law, a kind of code beyond what you're strictly obliged to do, whether it's committee, whether it's international morality, but that's always informed how we understand international law and what states ought to do more generally. All right, so that's, I think, the plausibility. I think it's there, and so that it sounds familiar. The question, I think, is how one evaluates the theory, right? So it's plausible. Is it useful? Where does it take us? Either as a descriptive or normative project. And I think so. Well, the first question I want to ask is, what does a theory do better than existing theories, right? What does it shed light on? But international law itself, it has its own little theoretical cottage industry, and has had for a while, hasn't thought of. And then by contrast, when is the theory relatively less helpful? How, for example, do you avoid the criticism that when you have a hammer, everything looks like a nail, right? But of course, if your starting point is the fiduciary theory, that you're sort of recasting every problem under the international legal sun as a problem of as a fiduciary problem, but in ways that may be oblivious to how international law has historically generated some of its own ways of understanding these dilemmas. So I think, the theory ultimately to me fares better and is better understood as a normative project rather than a descriptive one, even if it's a plausible normative project that, is not entirely utopian. And I think there's something to using a simple model from domestic law to highlight certain questions and certain aspects of international law that maybe are not well understood. There's questions about how fiduciary duties emerge. I think that we might be better addressed. I mean, do they just sort of emerge from power? Do they need the consent of those who benefit from them? Are they imposed top-down by international law? But I think when it comes, if you're using a private law analogy, that comes with, and I think Seth mentions this in this paper, limits to private law theory in, under sort of private law criteria, but also limits that might be demultiplied by the fact that you're transferring these sort of domestic tools in the international arena. And so there, I struggled a bit at times with how fiduciary theory might better explain the relationship of the people to its government or its sovereign than, for example, democratic theory, the theory of sovereignty, or international law to the extent that it has anything to say on how a state should rule. And then there's kind of intriguing problems with the idea of fiduciary duties. The demos is a bit restless as a beneficiary of fiduciary duties. It's not just a kind of inert object that just wants a fiduciary to be loyal to it. It's kind of talking back to the sovereign, and it's like, it probably has its own ideas on what its best interest is, and it maybe doesn't want to sort of delegate things that much to the sovereign. And so ideas of procedural responsiveness, accountability are quite prominent in democratic theory in ways that they may be less so in fiduciary theory. I think there's also something, and you've acknowledged this, that fiduciary theory does not lead us inevitably to international human rights, international humanitarian law, prohibition on genocide. To do that, you need all kinds of intermediary variables. And there, I think there's sometimes a risk of this becoming a theory of everything. So I was kind of wondering how one could, in maybe future work, focus more on what's really specific about fiduciary theory that doesn't require sort of buying into the whole Kantian framework, which can be defended on its own grounds, etc. But to me, is a little distinct from the project of bringing the understanding of what fiduciary duties are to international law specifically. And so there's a few things that I thought of that I don't think you mentioned. So one of them is fiduciary duties as a critique of kleptocracy, right? And sort of a plundering of resources by sovereign elites. Now that strikes me as bearing very much a commonality with the traditional fiduciary idea. It's not just respecting human rights, etc., but not sort of dipping into the cookie jar, kind of, and not profiting as the fiduciary duty holder from the fact that you have these obligations. And then you could extend that, right? So maybe a sort of prohibition on international adventurism, engaging in wars in which you drag your people but they really don't benefit from, right? Where you're really sort of abusing that fiduciary/sovereign mandate to do things that don't maximize the interest of your population. And then there's, I think, one area in which fiduciary duties really have a sort of comparative advantage is the whole part of the book that deals with duties towards aliens, and I understand that's the new project. And the reason for that is domestically you're competing with all kinds of theories of sovereignty, democracy, etc. So I've always, delegation, agency, etc. It's a very dense field. When it comes to the obligations that the state owes to people that have actually no citizen democratic relationship to, sort of the extraterritorial aliens, actually neither democratic theory certainly, nor sovereignty, nor international law even have traditionally had much to say. So the bare relationship one owes to these people, to at least keep them in mind when one makes foreign policy decisions. That looks a lot more like something that where fiduciary duties are quite appealing, I think, as a model. And there's another, I think, problem. Look, I mean, I understand that it's all other things being equal, we'd all rather be governed by princes who think they have fiduciary duties towards us, right? There's something a little problematic in the book about how fiduciary duties just kind of follow from the exercise of power without problematizing, you know, why are you exercising power in the first place and who asked you to be my fiduciary, right? And so, you know, the occupied Palestinians, indigenous groups, or the Catalan might be forgiven for being a bit ambivalent about some government holding itself to fiduciary standards, when, as far as they're concerned, the real question is, what gave you the right to govern us in the first place, right? So if I'm going to be occupied, I'd rather it was my benevolent occupier, but I'd be a little wary that in sort of insisting that the occupier has all these fiduciary duties, I'm also empowering that occupation. So, you know, who will rid us of these well-intentioned, scrupulous, but ultimately unwelcome fiduciaries? And then I'll skip because I'm taking a little too long. There's something there also, I mean, in an era of kind of shithole countries and sort of post, you know, invasion of Iraq, etc., do we need one more theory that tells us when states are not, you know, being the good fiduciaries that they should be, and therefore have sort of implicitly relinquished their sovereignty and have to let the kind of hegemon move in to sort of, you know, reform, rebuild, and take over, right? I'm not saying that's what you're exactly arguing. I'm saying there's a certain point, right? A slope that could lead in that direction. So what lies ahead? And I'll just finish with this. And I thought the whole conversation with Jens was really interesting. So maybe Evan and Evan's book will be the goose that will kill the goose that lays the golden egg, exposing the dirty secret of Hughes Coggins, which was there was always naturalist, and therefore, you know, undermine Hughes Coggins in the eyes of a positivist gatekeepers, right? So you like, so if they're the international lawyers, well, you know, you should never have mentioned this, you know, just Hughes Coggins is Hughes Coggins. But I think a more likely outcome, you know, aside from a small possibility that, you know, the populations of the world will finally see the light, and that, you know, natural law will be kind of restored, people having read the book and finally seeing this as sort of true natural law. I think more modestly, a word such as this, naturalist, neo-naturalist, or simply and modestly jurisprudential, will remind us that our positivism was always infected or fertilized by naturalist thinking in the first place, and that the ability of international law to be what it is has always rested on the power to imagine what it could be. Thank you very much.